Good afternoon, everyone, and thank you for joining us for today's webinar. As states around New England are reopening, condominium communities have questions about opening amenities, enforcing safety protocols, association liability risks, and more. Today, our presenters, who are Massachusetts condominium attorneys, will answer the questions association board members and managers around the state are asking. Before we start the presentation, I'd like to thank our sponsors who have made this webinar series possible and give them an opportunity to introduce themselves and their companies. Our first sponsor, Criterium Dudka Engineers and Stephanie Senecal. Stephanie. So we seem to be having,
oh my goodness.
Oh, there you are, Stephanie, hi.
Can you hear me?
Yeah,
Hi.
Hi, Stephanie, thank
Hi.
you.
Sorry about that. Thank you for the opportunity to sponsor this event. I'm Stephanie from Criterium Dudka Engineers. We provide structural analysis and design repairs, transition studies and reserve studies, and expert witness services, and we can do construction monitoring and bid, go out to bid for you if you have a big project coming up. We are the Massachusetts office of Criterium Engineers, which is a national corporation.
Thank you, Stephanie. And our next sponsor, Mirione Shaughnessy and Udy and Dave Udy.
Hi, everyone. My name is Dave Udy from Mirione Shaughnessy and Udy. I'm one of the presenters today, along with Chris Malloy. Our law firm is essentially a full-service condominium and real estate law firm. We specialize in everything you can conceive of with condominiums. We have offices in Londonderry, New Hampshire, Quincy, Massachusetts, and Duxbury, Massachusetts. And we're very grateful for the opportunity to sponsor today and to present today to you. Thank you.
Thank you, Dave. And our next sponsor, Moriarty, Troyer, and Malloy, and Chris Malloy.
Hello, everybody. My name is Chris Malloy from Moriarty, Troyer, and Malloy. We are also a full-service condominium law firm, which hopefully will become apparent after a segment of the presentation. We have offices in Braintree, Boston, and Falmouth down on the Cape. And we're just really fortunate to be invited by Claudette, Adina, and the chapter to both present and to sponsor this program. And I'll be speaking to you in a lot more detail in a few minutes. So hopefully everyone is staying safe, and good luck with your reopening process.
Thank you, Chris. And our next sponsor, Belfour Property Restoration and Brian Sowers.
Hi, good afternoon, everyone. My name is Brian Sowers. I'm with Belfour New England Operations. We first obviously appreciate the opportunity to help sponsor this program today. Belfour is actually the world's largest independent disaster recovery and reconstruction partner. Very active member with the CAI on a national level, and a strong advocate obviously here in New England. We do assist with many condo associations when they do incur damage from fire, water, storms, and other perils. And we appreciate you folks keeping us in mind. Thanks for your time.
Thank you, Brian. And Perkins and Ansel, we have Scott Erickson.
Good afternoon, everyone. Thank you, CAI, for continuing to put on these informative seminars. We know this is a challenging time. We're all excited to start reopening, but there are a lot of questions that come with this, and it continues to be somewhat of a moving target to make sure that we're complying not only with federal and state guidance, but with best practices. We look forward to hearing from Chris and Dave today and to continuing to sponsor these educational events. So thank you.
Thank you, Scott. And again, I want to thank all of our webinar sponsors, because without your support, we wouldn't be able to do these webinar series for members. So thanks again. As I mentioned before, presenters today are Dave Udy and Chris Malloy. Both are condominium attorneys. Dave is a partner with Marioni, Shaughnessy, and Udy. Dave also is co-chair of the chapter seminar and conference committee, frequent chapter speaker, and condomedia author. Chris as well volunteers on behalf of the chapter. He speaks quite frequently and also contributes articles to Condomedia magazine. So with that introduction, Dave, I'm going to hand the program over to you to start the webinar.
All right, awesome. Well, welcome everybody, and good afternoon. Chris and I have a lot of good things to share with you today, and it's kind of an exciting time given that things are starting to reopen. The first thing that Chris and I would like to tell you guys is we're here to answer your questions. What we'd like to do from a format perspective today is to save your questions for the end. So if you want to submit your questions in writing through the platform, we're looking at them, and then we'll answer your questions when we're done giving our sections of the presentation. Chris and I thought that a good place to start would be kind of to recap where we're at today and give a brief timeline of how things have unfolded here in Massachusetts. And then I'm going to talk about condominium boards and property managers dealing with vendors and construction projects on site, both in common area and units. And then Chris is going to talk about the important topic of how do condominium boards and managers deal with opening up amenities and things like that in their community. So all good stuff, I think, going forward to help you guys navigate, which is kind of an uncertain maze of what's going on right now with this reopening. So on the slide that you see right now is basically where things stand today. And to go back in time a little bit before now, only a few months ago, although it seems like an eternity ago, from then until now, the stats show us that Massachusetts has been basically one of the hardest hit states in the United States, with over 105 confirmed cases of the coronavirus, COVID-19, over 7,500 deaths, and they've administered here over 708,000 tests. Going back about 3 months, when the pandemic was starting to take hold here, on March 10th, Governor Baker declared a state of emergency in Massachusetts. And I know for me, it seems like, almost years ago when that happened, but it was only 3 short months ago. Shortly thereafter, a couple of weeks later in March, on the 23rd, Governor Baker issued an executive order essentially closing all non-essential businesses and prohibiting gatherings of more than 10 people and providing for a stay-at-home advisory. So it's very close to him having ordered people to mandatory stay at home. It gave people some guidance as to going out to go grocery shopping or go to pharmacies, but essentially it was a shutdown order for most of our businesses here and telling people to stay indoors. Certain businesses were deemed essential, and I'll get into that in a bit, but most of the businesses fell under that shutdown order. If we can go to the next slide, please. A few months later, Governor Baker issued a safer at home advisory. This was a more relaxed order, allowing for people essentially to use their good sense about whether or not to stay at home. It signaled the beginnings of things opening back up here in Massachusetts, which led to an order or an announcement, I should say, on June 6, 2020, where Governor Baker announced phase 2 of a 4-phase reopening plan, that the phase 2 would begin in a couple of days on June 8th, with each phase to last a minimum of 3 weeks. And it would be very data driven as to when each phase would then come to fruition. So for example, if things had not changed materially, then phase 2 would not shift to phase 3. Some of the quotes from this June 6th order are listed here. Essentially, Governor Baker said that businesses and sectors set to begin opening in phase 2 are subject to compliance with all mandatory safety standards. And Chris and I are going to go into some of those standards today that apply to the topics that we're talking about. And this was a very telling quote, I think, from this order, because I think it sets the tone for the reality that we're in. And the order, the announcement said, until a treatment or vaccine for COVID-19 is available, life will not return to normal. So I think what we're talking about today is going to be really pertinent, because I think this pandemic is going to be with us for some time, for at least several months going forward, perhaps into next year, until a vaccine becomes widely available. So a lot of the stuff that we're talking about today with, because in the meantime, for these communities, for your condominium community, your HOA, life goes on and things need to happen. There are construction projects that need to occur. There are amenities that people want to use. There are questions about whether unit owners can invite outside people into their units to do work, and how do boards deal with that, with juggling their responsibilities. Next slide, please. So I'm going to talk about what I mentioned earlier, essentially what do boards do with respect to condominium construction projects, and what are the standards that have been put in place for boards to deal with them. And as I'm sure all of you know, condominium board members have a fiduciary duty to maintain the common areas in a good state of repair. Now, it's an open question, do boards have a responsibility to protect unit owners from a pandemic? I mean, I think in some circumstances, folks could say yes. In other circumstances, folks could say, that protection's, that job is not absolute. It shouldn't be up to a board to handle every aspect of that. But it gets a bit gray, and that's why I think these standards that we're going to go into today are pertinent. So boards have that fiduciary duty, but there's a competing aspect of things going on too. I don't know how many people on the webinar today are in this situation, but some people live in communities where it's a phased community, and the developer still has retained rights to phase in additional units to the condominium community. And when that right of phasing occurs, or the developer has that right, most developers are motivated, and this is not a slander to them, but of making money. And they want to phase these units in as fast as possible, have them built out, and sell those units. That necessarily entails a whole gaggle of people potentially on your community's common areas building out the units. So some communities, and I'll go into a particular story that I've encountered in my law practice, some communities have that situation going on right now where a developer wants to phase in units. And to do that. In addition, I should say that another, I think, big issue is that in condominium communities, sometimes there are unit owners that want to do a home improvement project to their unit, which will necessarily involve several trades going in and out of the common areas every day to access that unit to do that work. So you can see that there's a potential during this pandemic, the board's duties and the developer's construction activities, or a unit owner's desired construction activities, can conflict with keeping unit owners safe during the pandemic. So how do we deal with that situation? Next slide, please. So we talked about earlier about non-essential and essential businesses according to Governor Baker's order. Quote unquote, construction related activities are deemed quote unquote essential by Governor Baker's executive order. In other words, they're legally allowed to proceed even in the earlier phases of the phased reopening plan. Massachusetts has promulgated a set of what's called safety standards and checklists for construction. And we put the link up there where you can access that. It's a pretty lengthy document, but it's not written in too much legalese and pretty easy to read. But this document, I think, is very important for condominium boards and property managers to look at, because it sets a set of standards that if there's going to be a large common area construction project going on, standards that boards and property managers should take a hard look at for wanting to implement and have in place when a project is going forward. And you can see too that construction-related activities being deemed essential, that goes hand in hand with that tension that we talked about. The Commonwealth is saying we want construction projects to proceed, we want housing projects to proceed, and boards and board members and property managers saying, whoa, hold on, you know, a massive common area construction project could create issues for the unit owners on site, whether a developer wants to do it or whether the board wants to do it. You have to kind of find some harmony between allowing such projects to go forward and keeping people safe. Next slide, please. So I wanted to go through some of the key takeaways from the construction standards that were set forth. This by no means is meant to be an exhaustive list, but I want to highlight a few of these standards for you just to keep them in your head, and you can go look at the document yourself. The checklist particularly is a nice kind of Cliff Notes summary of the document. The first one is that the contractor has to employ a site-specific COVID-19 officer. This is the person that is supposed to essentially put plans in place, submit daily reports, to essentially act as a liaison between the municipality and the owner of the project. That in this case would be the board or the board's designee, the property manager. Number 2 here, it says the COVID-19 officer shall submit a written daily report to the owner certifying compliance with standards. And that's except in the case of a remodel of a 1 to 2 family residence. So arguably this probably wouldn't apply if a unit owner is trying to do work inside to his or her unit, but we'll get to that in a second, and some things that board should consider in that instance. Next slide, please. The third takeaway from this document is for large projects, a contractor should submit a site-specific risk analysis and enhanced safety plan for COVID-19. This can run the gamut from what places are being accessed, how many people can have exposure to the project, how they're going to deal with that with social distancing and keeping people sanitized. This plan the standard here is pretty amorphous, but what's required here is some detailed plan to mitigate risk. The fourth takeaway is workers on site must report any COVID-19 symptoms to their supervisor immediately. Next slide, please. Each job site has to have cleaning and decontamination procedures that are posted. Obviously, it goes without saying that social distancing at least 6 feet is required, and hand washing stations must be provided with soap, hand sanitizer, and paper towels. I would argue that, you know, in the instance of a large common area project, that the contractor would have to provide those stations to its own workers, and that's not something that the board need to provide. Next slide, please. Another takeaway is that all the surfaces where this work is occurring have to be regularly cleaned and disinfected at least once a day, and all workers are required to wear cut-resistant gloves. Next slide, please. The next takeaway is that if the contractor learns that any of its people have suffered an infection of COVID-19, the contractor has to immediately notify the COVID-19 officer in place and the owner of the project. Here, that would be the board or the board's designee and the property manager. And after a worker with COVID-19 symptoms has been asked to leave a job site, the contractor has to immediately sanitize common areas and workplaces. I should say here that the standards here protect the identity of the worker who had the diagnosis, because there's privacy and HIPAA protections, but that doesn't mean that the contractor can't not tell the board that there's been someone with an infection. They have to do that. Next slide, please. So we've been talking a lot about what to do with contractors on site, whether it's a construction or a capital improvement project, either to the common areas. But I would say that these standards should also be used by boards in the instance of vendors that are coming on site. You know, these could include landscapers, and Chris will talk about this more, pool cleaners, things, other professionals. I won't get into that too much. But I would say that the boards can use this standard, this document about talking about what standards should be in place for people coming on site, and they can tweak them for vendors, and they can require vendors to adhere to similar standards with protection, notice, and communication. It's a good template that boards can use to put a protocol in place for whoever's coming on site. Next slide, please. So for construction project and vendors, what should condominium boards do? You know, here's my thoughts on what boards should do. Number one, require all contractors and vendors coming on site to follow these safety standards for construction promulgated by Massachusetts. Absolutely require that. And what I would say up front is what boards should do if there's a capital improvement project, or if there's an emergency repair project that has to occur, or maintenance that has to occur because life goes on while this pandemic is occurring. I would have the board and the contractor or the vendor enter into a written agreement that, among other things, requires adherence to those standards. The second thing that I would recommend is require contractors and vendors to work in one common area location per day at a time. The risk here is that, particularly in communities with elderly populations, there's a big concern of if there's a big project going on, that owners don't know where the people working on the project are going to be at any given moment, and they could run into them. There's also the chance that a lot of the common area could be tied up with this project all at once, which limits the people who are living in this community from getting in and out of their units. So if the contractor and the board can agree to a schedule whereby day by day it is known ahead of time where the contractor is going to be, and it can be limited to one specific area of the common area at a time, that provides some surety for the people living in this community where these outside folks are going to be, and that they can avoid them. And then that specific common area where the work is occurring can be cordoned off so the unit owners don't come into contact, or the unit owners see in an obvious way where the activity is going to be taking place so they can steer clear if they want to. The other very important thing, and this goes towards both unit owners retaining an outside contractor to do work in their unit, or boards commissioning a common area project, is to have defined and limited ingress and egress area route for the vendors and the contractors. In other words, there may be many different ways to get to the job site on a common area, or there may be many different ways to get to Mr. Smith's unit to do work in that unit. But to require upfront in writing the only route that these people are allowed to go on to get to that destination, just single one route out. And again, let owners know so they can avoid that route if they want to. Next slide, please. And I touched on this earlier, but it's very important, I think, in your written agreement with the vendor or with any rules that boards put out, is to have a communication line set up with the contractor or vendor to know in advance about each next phase of the work and emergent situations. Like one example could be every weekend, the vendor or the contractor submits in writing through email to the property manager where they're going to be next week, what locations, and then the boards can provide that information to the unit owner so they know in advance where the schedule is going to be, where folks are going to be, how they're getting in and out, so they can avoid those workers if they want to. And that bleeds into the next point here, that boards should communicate with owners ahead of time about each next phase of work, scope and location, and about ingress and egress area, so that owners know ahead of time, if they want to avoid these folks, here's where they're going to be. And lastly, I would say, advise that boards should monitor the work being done and shut it down if the contractor or vendor does not comply with these guidelines. They certainly would have a right to do that. The boards are masters of the common areas and can do that and can create rules with respect to the common areas. So the boards have that power to do that. I should say too that in all of this, boards have the right to make rules with respect to the common areas. And typically under the law, boards do not have much say as to what activities can occur in an individual's unit. So in this case, there's a tension between if a unit owner wants to do something in their unit and the board is trying to keep the common area in good order during this pandemic. I would contend that boards do have a right to make a rule with respect to how people access the common areas to get to a particular unit to perform work. So boards should consider memorializing some kind of rule about outside vendors during the pandemic period, how they can access units, outside contractors, how they can access units when they want to do work in those units. And then the board can communicate that information to unit owners. So again, there's some predictability as to where these outside folks are going to be. I just want to end this with my section of the presentation with a brief example on this as to how real this is. I recently had a condominium client who there was a developer phasing in one more phase of their condominium. And the board had no say in that. It was in the condominium documents and it was allowed to proceed. And the developer literally started work on a massive project involving, I think, 6 to 8 additional units in this condominium complex. Had a whole assortment of people coming in and off the site. And this was, I think, back in May. And the board issued a ruling and said, no, you cannot come and do this right now because of the pandemic. We need to work out some rules of the road. And the developer retained counsel and sued the condominium board in court, arguing that these projects were essential projects, or this activity, construction, was essential. We actually litigated this issue, and I was brought into the case to assist this board. And what grew out of that is a good written agreement that allowed this construction to continue, but that contained many of these rules of the road, allowing for predictability for the owners on site. And it really worked out well once that written agreement was in place. It allowed the developer to do its work and allowed the board and owners to have some idea of where the work was occurring to keep people away from it. So it all kind of worked out in the end. But I would advise people, rather than get into a direct confrontation that leads to litigation over this, to work through it using some of these guideposts. I'm going to turn things over to Chris, and I'll be back with Chris at the end of this to answer any questions that you guys have. Thank you.
Thanks, Dave. As somebody who, or as an attorney who in the course of my practice has to deal with a lot of construction related questions and activity within the scope of condominium governance and whatnot, I thought that was incredibly helpful and thorough and should be a great resource for everybody going forward. I think that's as comprehensive as you can get on construction in condominiums in the COVID era. So I'm going to transition a little bit and start talking about some of the common areas and amenities that associations and boards are looking to evaluate whether to open, when to open them, whether or not at all to open them, and sort of what considerations and concerns and regulations they need to be aware of as they're engaging in that process. So we're going to take a look. This is sort of a general overview of the topics we're going to cover in my segment. So we want to look at this as kind of a holistic approach in terms of opening amenities. A lot of associations have no amenities. Some associations have several different types of amenities. So one of the things you want to consider when evaluating what to open and when to open it is whether or not a phased opening makes sense. You don't necessarily have to open all your amenities at one time. And another concern is whether you need to open them at all. And we'll get into some of the details as to the costs and liability associated with opening it in the first instance. So regardless of what amenities you open, when you open them and whatnot, at least for the foreseeable future, and I think Dave touched on this in his overview of when we're looking at the life back to whatever the new normal is, there are some considerations and sort of mandatory minimum guidelines that associations are going to want to maintain whether or not you open amenities. And I'm quite certain I don't need to go into these details, but I've got them listed here because everyone's been given them ad nauseum at this point. But you want to maintain your social distancing, face coverings. A lot of associations are requiring face coverings in the common areas, in the elevators, in the lobbies and whatnot. Hygiene protocols, providing hand washing stations, disinfectant stations, reminding folks to use hand sanitizing stations. And again, these are just general common areas that will never be able to be closed because they're means of ingress or egress to the association. These are things that you should have been doing already, and if you're not, you should implement as sort of soon as possible. So One of the other things is signage. Signage is very important from the perspective of association, risk and liability. You want to remind your residents to adhere to the guidelines that the board has implemented and that the states and localities have implemented. So signage, we'll talk a little bit about what needs to be on those signs in a moment. Staff training, to the extent an association has staff or has employees, training them on the protocols is going to be important as well. So next slide, please. Okay, sorry, I got knocked off there for a second. So this is the kind of an overview of the progression and evaluation a board should be engaging in when opening an amenity or other common area. One of the most common questions we're getting is whether boards have to open an amenity simply because the state has allowed you to. And the answer to that question generally is, well, in all circumstances, is no. You don't have to open it. There are certain considerations that go into opening and not opening, but simply because the state has said, for instance, pools can open, doesn't necessarily mean that you need to open your pool at this particular time. So what we want to do as we go through the progression is we want to review and evaluate the state guidelines. What is allowed, what isn't. Currently right now we're in phase 2. We'll talk about this a little bit more in detail in a moment. Pools can open, gyms can. Gyms are going to be in phase 3. Again, we'll have more on some of the specific amenities in a moment. But when boards are considering whether or not to open an amenity, there's going to be varying degrees of risk, liability, costs associated with operating the amenity. And all of these factors are going to be different from association to association. It's going to be dependent on where you're located, what the amenity is, what is the configuration of the amenity. It may be that you can't functionally open the amenity and also adhere to the restrictions and guidelines that the state or locality has put into place, because it's just impossible based on how your amenity is either laid out or configured. And again, we'll talk about some of those specifics in a moment. Next slide, please. So I think we're one behind here. So that's what we just sort of went through on the timeline. So the next slide from there, Adina, please. Okay, great. So how do we assess and how do boards assess, can we open, when do we open? And one of the first things we have to do, the very first question the board and manager, and sometimes the attorney is going to have to ask is, has the government allowed our particular amenity that we're considering to open to actually reopen? If not, when do they expect to? Because clearly without that, without that guidance and that authority, we're not going to be able to open the amenity. So there's 3 levels of government who are going to issue guidance and restrictions. And we've seen, bits and pieces come from all 3 levels. So at the federal level, we're talking about generally the CDC, OSHA, and whatnot. And these guidelines have become a lot more general in nature. It's generally been left to, for several weeks now, the individual states to put together and implement reopening plans and reopening guidelines. So in Massachusetts, which is what we're talking about today, this has been implemented by and executed by the governor's office, mainly through executive orders. By now, we've all heard about the 4-phase approach, and that's how Massachusetts and some other states have really carved up what we can do in each phase, how we move from one phase to the next, and when things can be open. And everybody's sort of been living on a phase timeline for the last several weeks. So the governor's office has put out a number of guidelines and restrictions as we move through the phases, and that's going to be the most, or the guidance or the restriction that you want to look to the most when you're starting your process. It's really important. One of the takeaways from now And from 2 weeks ago and 3 weeks ago and going forward is to stay on top of these orders as frequently as possible. Because sometimes they change daily, sometimes they change hourly. Even after amenities are allowed to open, there may be clarifying guidance or more restrictive guidance, which is issued after the opening, depending on how the COVID data is coming in, as well as how businesses, property owners, and whatnot are actually responding to and adhering to the guidelines. Dave alluded to this in his opening. Some of the things that we lived through 3 months ago, we certainly, it feels like years, since we actually had the first and immediate closure. And I think I said this in another webinar, but if you had told me 6 months ago that in order to go to a restaurant, you need to have my temperature taken, I would have told you were crazy. I probably would have also told you that you're violating some type of law, and now that's a commonplace. So it's really important to stay on top of these as manager, as a board member, and as counsel as frequently as possible. Another thing to remember is that in addition to the state guidance controlling, one of the things that we've been seeing a lot in the questions we've been receiving is the more general the federal guidance gets, it seems in certain states, and especially Massachusetts, the guidance on the federal level seems less restrictive than the guidance you're seeing on the state level. So folks are saying, well, the federal government doesn't mandate this. The CDC doesn't seem to mandate this. Why do I have to follow it? And that's because the states are empowered with the ability to implement more restrictive guidelines. So you want to first start looking at the state. Even if the federal guideline is less restrictive or cumbersome, you're going to need to follow the state guideline, and that's what you're going to be expected to adhere to. The opposite of that is also true, that when you move to the local level, while the state may have established its own guidance, there are certain cities and towns which have more restrictive rules and restrictions. And you're going to see this, one of the areas you may see this is pools, where the state's going to establish a maximum capacity of 40%, we'll get into the pools in a minute, but 40% of operating capacity of a pool. A individual city or town may establish something like 25%. So in that circumstance, you then can't rely on the state like you would on the federal in my previous analogy. You're going to have to rely on your what your local or city ordinance and regulation is. So when working through your reopening plan, you need to consult with your manager and your counsel to make sure that both the state and the federal, and the local requirements are being met. Next slide, please. So once you've resolved the question of can we open, the next question you're going to have to look at is should we open? And one of the most important questions to ask as a board with the consult of your manager is, can the amenity be opened safely? And that means an honest and really a reasonable evaluation of whether an association can not only implement the restrictions that are needed, for example, limiting the number of people at the pool, or well, that's probably the best example, but can you actually enforce the restriction? And that second piece is really what I think is giving boards a lot of trouble in New England and in Massachusetts when you're operating a seasonal amenity. If there's really no ability for an association to enforce, either because of the cost for enforcement, inadequate staffing needs, something along those lines, that board really needs to take a hard look as to whether it's safe to open the amenity in the first place, or simply kind of just table it until next year. And that's going to be on a association by association basis. There's really no guidance counsel or managers can offer broadly to all associations because they are very much different. Opening amenities are naturally going to draw more people to congregate together, both inside and outside. And the reality of that is that it's going to increase the risk of transmission of the virus, which unfortunately can also risk a possible claim or increase the possibility of a claim against the association. So there are steps boards can take to reduce the possibility of that actual viral transmission But I think everybody knows, hopefully everybody knows at this point, at least right now, there's going to be no way to eliminate that risk other than not opening the amenity at all. So along with that risk of transmission, there's, again, unfortunately going to be a risk in potential liability and exposure for boards to lawsuits brought by people who claim to have been infected while using a certain amenity, a pool, a gym, clubhouse, anything along those lines. We haven't seen these claims really have been filed and asserted yet, but they're coming. And it's reasonable to assume that we're going to see our fair share of those in the coming years. Generally, I think it's going to be very difficult for many of these claims to get traction. And I think it's going to be difficult to prove where the person or a claimant to prove that they actually contracted the virus, where they say they contracted the virus. But even if a claim is meritless, a board is still going to have to respond to that when it's sued. So normally, pre-COVID and pre this environment, a board who gets sued or has a claim asserted against it is going to look to its insurance carrier for coverage and defense costs when it's sued. But claims related to COVID-19 are going to present a problem for boards. And this, frankly, is another webinar all in and of itself. So I'm going to hit some of the broad strokes of insurance and whatnot. But these are high-level topics, but they're obviously going to be specific to your individual policy. So I would recommend you consult with your counsel and your insurance agent on anything specific to your association. But as most people know, you're going to have two types of coverage as an association. You have a master policy, which is your general liability policy. And that covers property damage, slips and falls. It's really, covers all the operations of a typical condominium. Most of these, virtually all of them, I've yet to see one that doesn't have one of these, but they have what are called virus exclusions. So any claim, basically it's a policy that says, we're going to cover you. Anyone gets hurt, injured, sick on your property, we're going to cover you, with the exception of if it occurred because of the virus. So any claim on that, on the master general liability policy, is likely to be denied, pretty much outright. The other coverage that's available, and hopefully most boards have, is what's called directors and officers policies, which are more sort of colloquially referred to as D&O policies. These policies generally cover the decisions and the actions made by a board. But the importance, so you would think that if someone were to sue a board for contracting COVID because of something the board did or did not do, that these policies would kick in and provide the defense and indemnity that you're looking for. A lot of the D&O policies exclude personal injury and bodily injury claims. So coverage is unlikely to be found here too. So the big takeaway there is the result is many boards are going to have to pay for their own attorney's fees in defending a claim that's brought by someone who claims to have contracted COVID while using an amenity. There may not be a whole lot of merit to the claim, but typically having the ability to kick it to your insurance carrier and at least have your defense paid is a nice safety blanket for boards that might not be available on COVID-19 claims. The caveat I'll give there is across the country, there are all sorts of insurance discussions happening about business interruption, increasing protections for businesses who are opening from COVID claims. And this is really an area that is going to take years to develop. So what I'm telling you now might not actually be a concern in a year, but right now, analyzing the policies that are typically procured and in place for associations, that's what you can likely expect to see. This is another reason, this insurance concern is another reason why it's very important for boards to be able to both implement and enforce the policies and restrictions that they've implemented. If a board can say in response to a lawsuit, these are the policies we put in place, here's how we implemented them, here's how we enforce them, then the liability and exposure on a claim is going to be significantly reduced. On the other hand, if a board simply enacts policies, puts them in writing, distributes them, but does absolutely nothing to enforce, that could support and sort of bolster a claimant who said they contracted the virus because the board failed to follow its procedures. Vendor contracts and agreements, I'm not going to get into too much detail on because Dave went through that thoroughly, but you want to make sure that all of your vendors, and a great example is a pool company, and contractors and whatnot, but pool companies, at least as it relates to amenities, is important, are providing documentation that they have adequate COVID-19 protocols in place. So if something happens on their watch, you can at least, say that you vetted your contractors and your vendors. One of the sort of things that isn't talked about on the forefront when it's talking about opening amenities, most boards are asking liability and exposure questions. One of the things that's driving a lot of the actual decisions when you get down to the granular level and you're looking at what it's going to take to open up these amenities is cost. And because of the increased restrictions that states and municipalities and localities are implementing, such as increased frequency of cleaning, additional staff needed to monitor capacity limits, enforcement of other rules, it's turning out in some circumstances to cost an association a lot more to open at a reduced capacity than it would be to open under normal conditions. So analyzing the costs is an important part of the process, and it really can be a valid justification to those owners who complain about the amenity remaining closed, because that is happening too. You're getting a subset of people who are concerned about an amenity being open, and then a certain subset of unit owners who are complaining that it's not open. And an increased cost oftentimes can provide at least adequate or adequate justification, placate a unit owner who's complaining about an amenity not being open. Next slide, please. So now you've both determined that you can open, and you've made the decision that you are going to reopen. What steps do you need to take to ensure the residents are protected and the board is satisfying the requirements of state and local mandates? So simple things, which are probably not going to come as much of a surprise to many of you on this webinar, but clear signage in as many locations as possible is important. Reminders to maintain social distancing, face coverings required depending on where you are and where the rules and procedures are for the particular condominium. Capacity limits. The CDC actually has signs available on its website that can be printed and laminated and posted in the common areas or any other areas that you're looking to use this. And it's a great resource if you don't want to have to worry about constructing your own sign. One thing that should be prevalent and on most signage throughout the common area and in anything that you disseminate to your residents is that the resident is using the amenity or the common area at their own risk. And this would apply more to amenity than simply getting in an elevator of a condominium, because that's a different story. But the association can't guarantee a virus-free environment. And that's something you want to consistently communicate to the residents. The simple fact that you've communicated it might not ultimately carry the day, but if you are consistently putting that message out and folks are on notice that there is COVID-19 going on, which most folks should be on notice of that, but the board is at least not lulling anyone into a false sense of security that they are immune from contracting it by using certain amenities. Because that is certainly a position that has been taken by some people, and boards should really take active steps to make sure that they're not either directly or indirectly conveying that they're guaranteeing some type of virus-free environment. The next thought in terms of how we reopen is waivers. And this has been one of the most frequently asked questions from boards and managers is, can I require a resident to sign a waiver before they use an amenity, a pool, a gym, a clubhouse? And the answer is yes. And whether or not that waiver is ultimately enforceable, may not really be determined by the courts for several years in reality. But it's good and it's prudent practice to require residents to sign waivers before using the amenities. It's important to remember that if a board has a resident sign a waiver, that doesn't exclude the board from its own negligence or its obligation and duty to implement and follow rules. So a great example is if the board sets a pool occupancy limit at 40% and has a resident sign a waiver and then allows the pool to operate at full capacity and doesn't monitor it, that waiver is not going to be very effective if a claim arises as a result of someone claiming they contracted the virus at the pool. Another issue with waivers is third parties. If a resident signs a waiver, say to use the pool, goes and uses the pool and ultimately contracts the virus at some point, then goes home or goes to a relative's house and infects them, that person that they've infected didn't waive their rights. They didn't sign the waiver. So the board's not going to be insulated or have any protection from claims from that person. So these are some of the issues that may arise down the road with the enforceability of waivers. Doesn't mean the board shouldn't use them, but I wouldn't think of them as an absolute shield to potential liability for COVID claims. The last thing, at least in this section, is to implement responsible and enforceable rules. And we've discussed some of this, but really the takeaway is not only do you need a responsible set of rules, but you also have to have the ability to enforce them. You really can't have the rules without the ability to enforce. And we've discussed this, but that scenario of having a great set of written rules, but no ability or desire to enforce them actually creates more exposure for the board on potential claims down the road. Next slide, please. So the board's authority to maintain and regulate the common areas, Dave touched on this a little bit. The board has the right to maintain, repair, replace, and make rules for the common elements of the condominium. So that's where boards derive their authority and their legal rights to create rules pertaining to the common areas and amenities. And we won't get into the specific individual amenities too much because they're broad, but an example of some general rules that we've seen are to prohibit guests, prohibit use of the amenity by individuals who've been diagnosed with COVID-19 or who have been exposed to somebody who's been diagnosed with COVID-19. And that one of the ways we address that is by putting that representation into the waiver language that we have folks sign. Limiting occupancy, using an advanced registration system, removing common furniture and shared equipment is another rule or regulation that boards are considering for a variety of amenities. Designate spacing, cleaning and sanitizing after each use. We'll get into some of that detail a little bit later when we talk about some of the specific amenities. Enforcement options. So enforcement options, they're very similar to how you would enforce general condominium rules that have existed for years and years and years. There's one question that's come in actually while we started is how to reinforce COVID-19 building policies. What do you do if residents do not comply? Can they be fined? Is it legal to fine them? The answer is yes. The fine must be reasonable. It must be consistently applied across all of residents. You don't want to selectively enforce. But if a board sets a policy in a common area or around an amenity and someone doesn't follow that policy or that rule, then they can be fined. It's important to, and your fines are going to be, in some circumstances, the amount of the fine is going to be limited by what's in your bylaws or your declaration of trust. Sometimes the board has broader discretion as to where to set those fines. But in the COVID world, fines don't generally seem to be adequate enough to protect the health concerns for other residents. There are a lot of associations who have very limited fining ability because their documents set the fine at some nominal amount, $50 or $100 or something like that. And if someone is violating a COVID policy and putting someone's health at risk, and you're finding them $50 a whack, then it's really not going to act as much as of a deterrent as you like. So a lot of associations are implementing sort of one strike policies, where if a resident fails to follow the rules, they're restricted from using that amenity at all. And that's going to apply to pools, gyms, and we'll get to gyms in a moment, but roof decks, other common areas. It's not going to be able to apply to elevators and means of ingress and egress, but you can still find those individuals who aren't adhering to those guidelines. Waivers, we've discussed the specifics on waivers and the drawbacks of some of the long-term drawbacks of some of the waivers. But if you do require them, the best practice is to actually require them. Collect them from everyone who used the amenity, not just from time to time. Gaps in enforcement of providing a waiver are going to create additional liabilities for boards. Next slide, please. So the one topic that seems to be on the top of everyone's list, and I'm sure a lot of people are either napping or been lulled to sleep and have now perked up because we're talking about pools. So pools were reopened by the state. Community pools were allowed to reopen on June 8th, which was the beginning of phase 2. As we've sort of discussed, we want to check with your local city or town because they may require and impose additional restrictions on top of what the state has imposed. So the next one, I don't want to go to the next slide yet, but the next slide is going to be a resource for everybody to look at everything the state has mandated, which we can't get to today. But some of the notes about what the state has imposed for pool openings are that you'll want to take away from here is hot tubs and pools, they remain closed. Excuse me, hot tubs and whirlpools remain closed. Face coverings are going to be required in accordance with the existing guidance that's out there. So face coverings on the pool deck and surrounding areas are going to be required. Masks and face coverings are not required while you're actually in the water, but you're going to want to maintain and still have rules about maintaining distancing while you're in the water. So the state guidance is that if you have a community pool, the requirement is you can have 40% maximum of your total occupancy for the entire space. That's not just your bathing load, but that's your pool deck, that's everything. 40% of your total occupancy. Your local authority, and we're still seeing these things kind of trickle in, may have a more stringent requirement, maybe 25%, maybe 30%. So you want to look at the state and the local guidance in tandem with each other as you're evaluating whether or not to open the pool. Sanitation, state's going to require, and localities are going to require that high touch areas be cleaned with a much, much increased degree of frequency. Shared objects need to be cleaned after each use. That could be lounge furniture. That could be pool chairs, handrails. These are all things that when we were talking about cost earlier, all these additional cleaning requirements may increase the cost for associations, but failure to do so may put you in violation of a state order or a local order, but also may increase liability on the back end if someone does claim to have contracted it while you were at where they were at the pool and you didn't clean, the association didn't clean or follow the appropriate guidelines. Signage, post is conspicuous and as much as possible. All of the rules, consider disseminating that to all of the residents, either as a general mailing or when they sign up for the pool. That's sort of a segue into my next comment is consider tracking the usage if you can. Some places are set up with online reservation systems, which is very effective to limit the capacity and take some of the burden off of folks who are required to monitor the capacity. It's also a good resource for the association if someone does contract the virus to be able to contact trace. So that's another, and while the association won't be the one responsible for doing it, that'll be done through a state or a local government agency. The ability to say, here's who was there will also show that the association was invested in having protocols that protected people. Locker rooms, changing facilities, they're still closed. Restrooms are not. Restrooms are required to be provided. at pools and whatnot. So those will be open, or should be open. Next slide, please. So this is just the front page of the safety standards issued by the governor on June 9th. This is the most recent guidance we have on pools. We've covered a lot of the points. We don't have time to go through everything, but this is a good resource for anyone who's looking to open a pool. You should be able to access this based on the hyperlink within the program. But if you can't, contact me or contact Claudette or Adina or the chapter, and they should be able to provide this. But this has a comprehensive outline of what you should be looking at when you're evaluating, whether or not you can actually open your pool. And if you look at, it might be difficult to see on here, but if you look at footnote on the first page, footnote 1, this order specifically names condominiums and brings it within its jurisdiction. So this does apply to condominiums. Next slide, please. So we're going to talk briefly about a couple other amenities. Roof decks is one of the common ones we're getting lately. And this can apply to other outside community shared spaces like courtyards and other areas where people congregate. The current guidance issued by the governor has it has relaxed the outdoor gathering size. Right now, more than 10 people, it used to be we can only gather up to 10 people. So more than 10 people can congregate outside so long as they are able to maintain distancing. That sounds easier than it actually is. I was actually at my first unit owner meeting last night, and it was outside, and there was an issue. I won't get into the details of why the meeting was necessary, but it was heavily attended, and it went for almost 2 hours, somewhat of a contentious issue. And it started with 40 or 50 people, all en masse, spread out in chairs, all 6 feet apart. By 30 minutes in, half the masks were gone. By an hour in, people were out of their chairs. By an hour and a half in, people were basically in a group talking among each other and conversing and clearly violating what the state considers to be social distancing for outdoor gatherings. So while that is certainly someone's personal preference to do that, we won't get into those types of conversations here. It is important when it's an association sponsored activity. In this case, it was a meeting. And sometimes it's just impossible to regulate and to monitor. But those are some of the consequences when you get a lot of people together in an outdoor area. So inside, still limited to 10 people. So keep that in mind when you are evaluating your space. It's important to remember that if your space can't accommodate social distancing with 10 people, then you're going to have to reduce the capacity to 6, to 8, to 5. Similar rules for the regulations for roof decks and outdoor spaces are similar for pools. You want no guests, sanitation, signage, one-way markers, furniture. You want to require unit owners to wipe down furniture if in fact you allow common furniture to stay up on a roof deck or in a shared space. Grills, we've been getting a lot of questions as the weather gets warmer on grills. Obviously the easy thing is to just have them shut down for the time being. To the extent that the boards want to open and allow residents to use grills, requiring residents to use their own utensils, cleaning after each use. Associations should increase the frequency of their cleaning as well when grills are going to be open. You might want to consider waivers for grills, maybe not roof deck access, but if you're going to be using a shared amenity, that's something you want to consider too. Next slide, please. I think I'm running out of time, so I'm going to kind of breeze through a couple of these things, but fitness centers and gyms, June 29th right now is the earliest possible date. We're looking at that. That's phase 3. We don't have the specific restrictions and guidance available right now, but as it was with pools and restaurants, the governor announced those just kind of days before they were allowed to open. So we expect the same or similar timing here, leading up to the 29th. I'm guessing, and it's the sense that smaller association gyms might be treated differently in some respects than larger commercial gyms, but we simply don't know for sure yet. So these are some of the things to plan for in advance. Again, they're similar to other usage of amenities where you want waivers, limiting machine use, wiping down machines, and so on and so forth. Some of the other amenities we may get questions on, but I don't want to get into too much detail with my time constraints here, but community gardens, don't share your equipment, stay in your plot. If it gets crowded, create a schedule. Tennis courts, those are okay, but no shared equipment. You again want to schedule, limit the amount of people. Contact sports are not allowed yet, so we would not recommend opening up basketball courts. Good resource, USA Tennis or US Tennis and US Basketball have great resources on their websites that talk about how to maintain and implement rules and restrictions for when these amenities can open. Dog parks, again, similar. Don't share toys, maintain distance, face coverings, use no-touch trash cans, things like that. Next slide. So this is, sort of the last topic I want to cover, and I'll do it quickly. We've talked about really how to get to the opening and what to do and how to evaluate it. But one of the things I want to close on is what happens if you have to close. We're starting to see in other states that weren't as aggressive in their closing, that they're having an increase in cases. Don't really know how that's going to play out, but they could be looking at a second round of closures, or in some of those states, a first round of closures. So boards, while they're doing their reopening plan, should at the same time be implementing a sort of reclosure plan as well. Because as we saw with how the original closures happened, it was overnight. So when you're thinking about, well, it's going to cost me X to do this and to open this amenity, what's going to happen if you invest all that money and then have to close in a couple of weeks? You also want to be able to act quickly and swiftly if the government does issue another stay-at-home order or does close certain amenities. You don't want to be in a position where you're not effectively able to close that, such as putting a cover on a pool or something like that. So while nobody wants that to happen, and nobody wants this circumstance to arise, I think it's important for boards to consider at the same time as how do we open? What if we're forced to close quickly? How are we going to do that as well? So that's all I have on my material. I think we're going to open up for questions.
Yeah, Chris and Dave, I do see some questions in the question box. Do you want me to read them or do you want to take them?
I can start on a couple and maybe I'll look at them, and I think I've been looking at them as Chris has been speaking, and I think some of them blend together, and then maybe Chris and I can both offer, our take on them.
Okay, so we're going to open up both your cameras then so that you can do that.
One group of questions concerned if residents, unit owners don't comply, can you fine them? And there were questions also like if residents don't comply with a COVID safety plan or don't comply with a rule to wear a mask, can you fine them? What can you do? And I'll give my 2 cents. My 2 cents is if your documents allow for fines, yes. I think if the board made a rule that tailored whatever the government is saying about what people have to do and they mirrored that, that's a pretty sound rule. I think if the board did a more restrictive rule than that, then it gets a little bit more tenuous as to what you can ultimately enforce if there's litigation about it. But I think Chris touched on it earlier that you want to make sure that whatever fines that you have or rules that you have are reasonable. I don't know, Chris, do you have anything else to add on that?
Yeah, so we've encountered this on a couple of different areas. One was actually in a construction circumstance where a board decided that it was going to put a moratorium on in non-essential, non-emergent, in-unit, and actually common area construction as well. And it was a fairly large association. And obviously recognizing that they don't have the absolute ability to regulate what goes on in the unit, they took the position that they can ban this because they wanted to limit the foot traffic in the common area for the purpose of protecting the risk of transmission and the health and safety of the residents. So this particular unit owner continued with construction in the face of this directive from the board. The board was only empowered with the ability to fine for $25 a day. And I know it's not directly on point to what Dave was talking about, but this unit owner was involved in a fairly significant rehab and just continued to work and is going to pay the fines. We ultimately achieved a resolution on that, but had that ultimately gone to litigation where the board sought an injunction or something, I think the restriction that the board implemented, it was for a short duration. It was narrowly tailored to protecting the residents. It applied equally to everybody across the board, or everybody across the association. That would be something that's enforceable.
Yeah, I'd agree. Couple questions concerning some stuff that I spoke to. It was, what if you don't want to shut down the project, but the contractor doing the project is not complying with the COVID-19 plan? And kind of baked into that, does the state or city shut down projects and issue fines? So my 2 cents on this would be, if you don't want to shut down the project, but the contractor's not complying with it, I think you can't have it both ways. If you have rules in place that the contractor needs to adhere to, and you really need to get the project done for economic reasons, I would assume, or just from a time horizon standpoint, at the end of the day, you have to enforce the rules of the road, the contractor, and the contractor's not going to listen. It's putting people at risk health-wise. I would recommend that the board give me or Chris a call and help make a demand on the contractor to tell the contractor to stick to what was agreed to, or else the board will bring suit. And to that point, I would say any agreement that the board has with a contractor, you should bake into that agreement a requirement that if anyone needs to file a lawsuit to enforce the terms of the agreement, which would include the COVID safety plan, then that prevailing party in that case would get their attorney's fees. That would hope to prohibit litigation, because the contractor wouldn't want to do something that clearly violated your agreement, because it would not only lose the lawsuit, but would also have to pay attorney's fees. Chris, I don't know if you want to add to that at all.
No, I agree with that assessment. There are a couple of questions here that sort of overlap a little bit, but pertain to more of my material than yours. I'm just going to tick off a few of them because the answers are relatively quick. One of the questions is, what is the process of creating a rule, vote of the board, or is it a vote of the board? And the answer to that is yes. Anytime you're regulating what's going on in the common area, then the board can do that by majority vote. You don't need to go to the unit owner. So without rehashing all of what Dave and I talked about in terms of what the rule needs to be in terms of reasonable under the circumstances and all that, the board is the entity that has the legal authority to do that. So that's one question. Another question is, would owners have a valid right to demand a partial dues refund for amenities that they cannot use? The answer to that is no. The budget was set. The budget was already done. People are paying common area fees on that. And so there's two parts to this question. There's the legal component, that they don't have any legal right to demand a refund simply because an amenity is not open. But then there's more of a practical response to these particular owners who are vocal about that, and what boards can tell them. And it's likely that the scenario in all cases is, because of COVID, there have been increases in a number of other operating expenses, increased cleaning, and having nothing to do with that particular amenity. So the board is in the association is incurring additional costs that it didn't anticipate. So not operating that amenity is offset by the increased costs in some other areas. Another quick question, and I know there's some more that are geared towards Dave here, but should we inform the residents as we open that if needed, we may have to close again? I don't think that it's certainly not legally necessary. I think it's not really going to impact a resident's use of the amenity. It may be something where you feel like you have a uninformed segment of the population that aren't aware of what's going on, and that's going to be, you know, association to association specific. But if you want to mention to them that these things are open, subject to further orders of and can be closed without notice going forward, that might be something that you want to say. But I certainly don't think that in order to preserve your right to close it in the future, you need to let residents know that you're opening, but you may close it at any point in the future. One other question on the pools is, do we have to keep the restrooms open, or can we keep them closed? I think that question, it doesn't mention pools, but I'm taking it as whether or not it pertains to pools. You have to keep the restrooms open. If you're going to open the pools, you have to have the restrooms open. You can't close them and have the pools open at the same time.
And to add to one thing that Chris just said, there's a question in there: what's the proper approach to communicate what the board is doing with respect to this? I would say just use whatever tried and true communication method that you have in place and that owners are accustomed to receiving from you. You know, the property manager can certainly communicate things. A letter can be sent out to all owners. There can be electronic communication to all owners, but clearly, you know, I think transparency and prompt and ahead of time communication is key for any of the stuff that we've been talking about today, because owners want to feel like their boards are being open and transparent with them. So communication is key, and the broadest possible way that you can do that, the better for boards.
Yeah, I agree. I agree with that, David. There's two questions here that sort of tie somewhat together. The first question is it a valid excuse to communicate to condo owners that an amenity won't be open because our insurance company does not provide coverage should someone sue over contracting the virus from that amenity? So the answer to that is yes. Boards don't need their insurance company to give them that quote unquote valid excuse. But we've gone over all the reasons the boards can and cannot open amenities, and that power rests with the board. You don't need to be told that you don't have insurance coverage for those. But that, again, there's two components to all of these sort of questions and the analysis that boards should do with their managers and counsel. Is there's the legal implications of it, but there's also the practical implications of how communities are run. And I think if that is in fact what you've been told by your agent, and it's likely what you've been told by your agent, because most of these policies don't have that type of coverage, and communicating that to unit owners, I think it's fair to assume that most unit owners don't know that's a reality of insurance coverage. So adding that in your communication, you don't need it to validate your decision, but it may be helpful from a practical perspective. And then the question that sort of tied into that was, question the lawyers, do you have many cases where boards actually got sued due to poor actions related to COVID-19? Do residents win these cases? I can't speak for Dave, but I think it's too early. We haven't seen any yet. I know of others in other states. In fact, one board, I think in Ohio, was sued because it didn't open something, and they were upset that they didn't open it. I think it's going to take some time for folks who claim to have contracted the virus due to something that a board did or did not do to really sort of play out. We haven't seen them yet. My assessment early was that I think it's going to be really difficult just from a scientific and medical perspective to prove that somebody contracted it where they say they contracted it. So I think a resident or anyone else is going to have an uphill battle in those suits. But we certainly, as we sit here right now, can't predict what the landscape's going to be and how different jurisdictions are going to respond to those types of claims. So haven't seen them yet. We know they're coming, and all of the things that both Dave and I laid out today are things that, if you do, are going to greatly enhance your ability to defend that case. I don't know if you have anything to add to that, Dave.
No, I completely agree with you. There's one question that kind of related to that is, are unit owners exposed to liability for board being sued for no insurance? And I think the answer to that is the owners themselves aren't exposed to liability personally, but financially they could be, because anything that becomes a common expense, whether a judgment against the community or attorney's fees to defend a case, what have you, that all gets borne as a common expense, and people have to pay out of pocket for those things. I think that's all the questions that we got, Chris. I'm not sure if there's anything else.
I did just see one. What are the rules about central air conditioners? Do we need some different filters? How do we know? My response to that is you should discuss that with your mechanical engineer or an HVAC professional. Make sure that your filters are adequately replaced. It's not realistic or reasonable to say that you should be shutting down your HVAC system because of the potential for transmission. I think board's best bets in that circumstance is to have your maintenance done, have your filters changed. And if there are concerns about the system, that you have an engineer take a look at it, or you have your HVAC technician take a look at it. But I don't think that that's necessarily something, we're going to see claims coming from all sorts of areas. But I, as an attorney, couldn't tell you what type of filters you should be having in your particular condo. But I think that's probably the best place to start. It doesn't hurt to do that. I wouldn't be overly concerned about that method of transmission.
Yeah, and in all of this, I think what Chris and I are getting at with you is don't be a penny wise and a pound foolish with any of these decisions. If you need to have a question about air filters with your air conditioning, spend a little money, or go to a trusted vendor who will give you that free advice and do it. If you need some short legal advice on how to do something, invest in that. If you need your property manager to go above and beyond to do something, invest in that. And if you can act reasonably in all these different decision points that you have, and you use qualified experts to help advise you, I think that's the best defense against any future lawsuit, both with people coming down with the virus, or if someone unfortunately does, to defend against any of those claims.
Yeah, I agree with that as well, Dave. I think as we were talking, a few more questions came in. There's one question: how about opening libraries, movie rooms, and game rooms? Should boards follow state and local guidance? Well, the answer to the latter portion of that question is yes. The board should be following state and local guidance as to every decision that they make in terms of COVID-related openings. Libraries, movie rooms, and I think the question just disappeared because Claudette clicked answered, but those types of things all seem to be indoor. So we know that indoor activities can take place. Gatherings are limited to 10, and you must be able to distance. So those things can open. But you want to do an assessment, if it's a small library or a small game room and you can't fit 10 people in there who can adequately social distance, then you don't want to open that amenity. If it's a bigger room and you can have folks in there, then you want to, you're able to do that. And so long as you follow the proper protocols. And then the next question was, how about, it says community benches. I don't know if that's supposed to be beaches or benches. Benches would fall into, I guess, it's actually an interesting question if it's talking about benches. Depending on the size of the bench, it's unlikely you're going to be able to accommodate more than one person without violating that 6 feet. So, I don't know that you necessarily need yellow caution tape up there to prevent people from sitting on a community bench, but that might be something that you want to put into a rule, or at least some guidance from the association to say only one person can sit on a bench at one time and wipe it down when you're done, or something along those lines. I don't know that it's necessarily, I think people need to, at the end of the day, I think people need to use some common sense when it comes to these things. And that may be a lot to ask in some circumstances, but, and if you're talking about beaches, then I think it's no different than the fact that beaches are open in Massachusetts. Outdoor gatherings are no longer limited to 10. You have all the same restrictions and protocols in place. You have to distance. If the beach has a capacity, you want to reduce it to an adequate capacity, and you want to have all the other same requirements that you would have anywhere else. But those would be allowed to open subject to those guidelines.
There's a question on here that says exposure to management companies if a board proceeds to open a pool against the manager's advice. And my take on that is most management companies in their contract with boards have an indemnification provision, which says if the management company is sued for anything arising out of the performance of their work, the board has to indemnify them. So I think that would take care of that. So any management company should check their contracts.
There's a question here. We have an indoor pool, which is now closed. How should we proceed with the reopening? Indoor pools should not be opened at this point. That we may see guidance on that in phase 3. But as far as we understand it, this allowance of outdoor pools to open the beginning of phase 2 applies to outdoor pools only. So we may, again, check back, keep checking with with the state and the local government, but my suspicion is we won't see that till at least phase 3. And then there's another question: how do we calculate capacity on a pool deck? What is the formula? The pool permit does not indicate capacity in the water, but not on the pool deck. I've received this question a few times. What I would do is, out of abundance of caution, I would check with the town, and I would check with either the building department or whomever the local office is, to see if they have anything additional for capacity for that outdoor space. Because the way the executive order is worded, if you make that decision based on actual pool capacity for in the water, then you'll actually probably, and you apply that to the whole pool deck, and you'll be okay because you'll be lower. But if you don't take into account the people on the deck, then you're going to be in violation, because it is 40% of the entire space. So I would try to do some more due diligence and see if the town can advise you. It may be, it's probably unlikely. Dave, you might have some insight into this. It's unlikely to be in the plans or the governing documents as to what the capacity is for that space. But your town, you're going to the town affirmatively and in good faith, so you can try to establish what your protocols are. So I think most towns will want to work with you with that, so you can set that up.
Yeah, I agree.
Claudette, do we have anything else that we haven't answered?
No, I think those are all the questions I've seen. I don't know that any more are coming in. So I want to thank our presenters today again, Dave and Chris. Great information. A lot of great questions came in. Adina, can I have the next slide, please? I just wanted to remind everybody that we will be doing all of these types of webinars in all of our chapter states. So if you're looking for this kind of guidance in any of the other chapter states, you can find the dates of those webinars on our website, CAI-NE.org. We also will be doing a governance program strictly for Massachusetts on August 11th to talk about issues regarding meetings, votings, document amendments. I want to take a moment to thank all of our chapter partners who support all of the things we do here at the chapter throughout the year. And then lastly, we did record today's webinar. We will make that link available to those of you who registered today.